Assumption of the risk. It's something we've talked about here on our video blogs previously, but it's a concept that is out there and has an impact, and that takes us to this week's case. Involves a real case involving real people. It was a woman. She was a professional home caregiver, essentially a nurse. And she was assigned by her employer to go to a home where there was an 85-year-old woman who had Alzheimer's. The home was also occupied by the woman's husband. All right, well, the caregiver's there. She's helping out. She's doing things. And one day she's washing the dishes when suddenly this 85-year-old woman with Alzheimer's comes up behind her and stabs her repeatedly. Well, after the nurse, the caregiver, got out of the hospital, got out of the kind of care that she needed, she brought suit against the 85-year-old woman's husband, contending that he knew of her tendency to engage in violent behavior. And apparently, it is a well-known side effect of Alzheimer's. So, the case went to court, and he, the husband, argued on his behalf through his lawyers, I'm not responsible because it's well known Alzheimer's can produce violent behavior. In this instance, my wife had a clear diagnosis of Alzheimer's. She knew that when she came to become our caregiver, and the employment agency that employed her knew all of that stuff. Therefore, I'm not responsible, and that is because she, the woman that was injured, assumed the risk. She came into our home knowing my wife had Alzheimer's, knowing Alzheimer's causes violent behavior. So, because she assumed the risk, she has no one to blame but herself. Woman on the other side said, no, hang on a second, you know, there are varying degrees of Alzheimer's, and in this instance, we did not have full notice of how violent she was, and accordingly, we didn't take the proper precautions because we had no knowledge of her extreme tendency to violence. Well, the case went up. Case went up on appeal. Went up on appeal to the Second District Court of Appeals in the state of California. And there, the appellate court looked at this and they said, you know what? Alzheimer's is a disease which is known to cause violent tendencies. This woman who suffered the injuries is a woman who is a professional. She's in the home care business. She's essentially a nurse. She knows these things. Her agency knows these kinds of things. So, both she and the agency volitionally and freely entered into this employment where they knew they were going to be dealing with somebody who had a tendency to be very violent, and accordingly we find she assumed the risk and she recovers nothing because she assumed the risk. Okay, so what do we learn from this? Well, we learned from this some things we've learned some of our prior blogs, and that's very simple, and that is that this doctrine of assumption of the risk exists and in fact can prevent someone from recovering any of the kinds of harms that they suffered from the responsible party if it is found under the facts that they assumed the risk when they engaged in the activity that caused the harms. All right, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.